Yeah, exactly. Yeah.
How early is it? That's pretty close. Yeah.
What is teacher?
Oh, I like that.
Yeah, she's been answering to it. Oh. She's a lot.
Do we have anybody on my?
Thank you all well.
John O'Leary accompanied me to
Why did it change the?
and then I had to kind of get back here and he was supposed to be there and I didn't know if that's okay. Like, no, we're back. Oh.
That's excellent. Better take a long.
Well.
Hopefully you're under there.
Yeah, and this.
Yes.
Probably, I got it right here.
You can keep us updated. Yeah, Sarah had said it's like.
Yeah, it's almost halfway.
Oh, wow.
Yeah.
All three. Home bus.
I did, yes.
That's good.
And I.
They did this.
I have some on this.
Very. Again, it's really great to have all of you here. We are happy to have Adam Perry here. And we're going to introduce him in a little bit. But first, let's open in prayer. Holy Spirit, allow us to receive knowledge, hope, and comfort as we gather here today. In your name we pray. Amen. Okay, Adam Perry otherwise known as Larry Perry's son, is an attorney specializing in estate planning, trust administration, and probate. Adam earned a Bachelor of Arts degree, magna cum laude, from the University of California at San Diego, and a Juris Doctorate degree from UCLA School of Law. He has an office in Mission Valley from which he and his partner serve clients in Southern California and throughout the state. Adam is admitted to practice before the courts of California. He's a member of the California Bar Association Trust and Estate Section and San Diego County Bar Association Estate Planning Trust and Probate Law. Section. Adam has been recognized by California Western School of Law for his contributions to their pro bono community law project. Adam and his spouse Marty enjoy spending time with their family and friends and living in Point Loma with their rambunctious Labrador. Thank you.
Thank you. Hey, well, thanks so much for having me this morning. This is my timer. I think I could talk on forever, and Carol's also gonna give me a note, and we are approaching question and answer time, because I don't want to take that away from anybody. Again, thanks for having me. When my dad and my Carol told me that you guys had organized this program, and you were spending as many days and hours as you are on end of life issues generally, I thought that was a wonderful, wonderful idea. So I'm just going to talk about a part of it, and it's going to be really informal. I guess we should probably hold questions unless it's just burning until question and answer time. But we're going to talk about broad concepts. And so we have some slides on the left and the right up here that match the handout. And so what we start with is just something that helps us focus on the components, right, of an estate plan. So we talked about an estate plan as opposed to a will or a trust or just something like that. The concept is, the reason behind it is that we're concerned about two main things, and there's not a single document or a single step you can take that will address everything. So the two things that we're concerned about are a lack of capacity. So if you're to lose capacity as a result of something like a coma, right, and you just simply can't communicate your wishes, Alzheimer's or dementia as we reach the end of our lives, when our body kind of starts to outlive our minds. So that's one thing that we're concerned about. And that's on the right-hand side. And those show documents that are effective only during life. Middle, of course, are documents that will apply during life and following death. And then the left side shows what we more commonly think about when it comes to estate planning, which is post-death distributions, post-death administrations, etc. But it's worth focusing on the two because the incapacity issues are they're just as consequential and even more difficult to deal with actually than the post-death issues. And so what we're going to do is we'll talk about what, as far as what exactly is estate planning. We'll talk about what it's not, and then we'll dispel some myths and leave everybody feeling a little better than they might have walked in. We'll talk about how, right? What are the documents that we use? What are the things that we need to communicate with each other? And then we'll hit some special topics, right? So special topics, we'll talk briefly about special needs planning, blended families, substance abuse, and California community property law. That's a lot to fit into 40 minutes. So let's just get started. And you're going to see me waking up my little timer if it starts to go to sleep. Okay, so we start with like a general concept where we're talking about default law. Would you mind advancing it one?
Thank you. I was gonna ask you to.
I'm gonna remember to tell you. Default law versus a concept of proactive planning. And so at its most, so this is both talking about what estate planning is, and we're gonna dispel some rumors and make everybody feel a little bit better. In one way or another, this is just a general 10,000 foot concept. In one way or another, we spend a huge amount of our time in our lives of arranging things the way that we like it. right? Either because it makes us feel comfortable, because we enjoy it, or we're prioritizing things that we value over other things that we don't value. I mean, if I just think about how much time and effort, my spouse and I have put into decorating our home, it makes me embarrassed, right? Because we have so many bare walls, we have empty walls all over the place because we ended up with two opinionated people. So we're not putting anything up until we will come to an agreement on something, so most of our walls are. But that's silly, right? That's just silly, but it means something to us on a day-to-day basis, right? It affects our quality of life. It's really important. And so those are things that we're able to do by and large without any legal intervention, without a need to document things in a particular way. We just do it, right? We think about it, then we execute. And that's because these things are under our own control while we have capacity, right? We don't have to worry about communicating with third parties about it. We don't have to worry about making clear what our preferences are because it's united, right? The decision maker and the person who's executing it is one. And so when we start to deal with incapacity or death, right, we just split that, right? So there's going to be somebody who carries it out, right? And so the person who carries it out is your agent. It's your executor, okay? It's your trustee. It's your agent under a durable power of attorney, right? And then there's you, the principal, right? Who's made the decisions regarding what he or she wants and makes it clear. And so once we split that up, by the very nature of dividing those two things, it takes work. And we need to be clear about things. And so that's what requires a certain amount of advanced planning and a conscientious approach to this sort of stuff. But that's only if we're going to invest effort in it, right? That's only if we're going to take time to try to carry through those preferences. So it's an opportunity for those of us to whom it's very important, right? It's an opportunity. I'm being silly talking about decorating my home, right? But this also relates to how you want to receive healthcare, whether you want to receive certain types of care, where you'd like to live, how you'd like that to be financed, those sorts of things. Again, we can discharge them ourselves when we have capacity, but when we have to split that and we have to rely on an agent, we need to start being clear. And so those are the documents, and we're going to talk about that, not staff. But again, I want to bust some myths today. I want to make sure people feel comfortable because oftentimes I hear some sort of a fear. I'm gonna interrupt myself. What happens if you don't do this, right? What happens if you don't take those steps? It's not the government is not going to get your money, right? It doesn't happen. It's too frankly, it wouldn't work, right? And in a democracy, we just don't go for that, right? The government's not going to take your money. The government's not going to impose a conservatorship over you necessarily. There's way too many people, it takes way too much time, right? It's just, I don't even know if the government wants to, frankly, I don't think it does. But from an administrative perspective, it's not possible, right? So let's bust that myth, right? We do not have to worry about inaction resulting in some sort of dystopian future where your money's taken from you, right? And you're shuttled off to some sort of terrible place. Not true, right? So what happens when we don't take any steps? You have an estate plan. Actually, you just didn't design it, right? How can the default law design your estate plan for you? And it's funny actually because it looks a lot like the medieval ages, right? Lineal bloodlines, right, are very important. And so, if we think about law as just a basic endeavor of humans trying to help humans and come up with rules that seem to make sense, the governing logic that they've decided is let's keep our property inside of our family. That's what they've decided. So you see on the far right-hand side, the way this chart works is you stop going down once you hit a box where somebody's living, okay? And so if you were to die and you owned property, it wasn't subject to you, and you expressed no wishes about it. You just had property and you died. It could be cash, securities, stock, real property, your home. Default law says it's going to go to your children, or if you're married, your spouse will be able to claim a part of it, and then your children will be able to claim a part of it. And that's what happens. right? We've just demystified that part, right? It does not go to the government. The government does not levy a major tax on that transfer or anything like that. There's no transfer taxes when it goes from one person to another. We'll talk about that in a second. So that's one of the things that's worth talking about, right? Is that if we don't take any affirmative steps, the default law in California can supply us with a form of an estate. And so maybe it's not a plan, that somebody made a plan and this is what's going to happen. And so what the graph shows as we go further from right to left is, again, think about it feels very medieval, right? But they want to just, the default laws in California want to distribute property to the relative that's closest to you, right? So they're saying spouse, which is not listed, and then a child. If there's neither of those, then we're gonna go to grandchildren, right? If there's neither of those, we're going to great grandchildren. None, we're going back to parents, they're likely deceased, right? So now property is being distributed to your siblings. Generally speaking, this does not stress people out, right? This is a default approach that has been decided, like a majority of the people in California would probably be in favor of this if they haven't expressed a contrary intention. So that's fine, right? That's great. So that's just illustrating this is one of the big ways that we reduce stress about the process generally. Now, I'm going to talk about how this is inefficient if we just rely on the default law and we don't take any steps. We're going to talk about that in a number of ways. But this is just a quick way to say, you know, it's not the end of the world. Okay, let's advance a slide. So am I going to be taxed, right? Is there a death tax or an estate tax? And the answer is yes, there is an estate tax. No, there's not a death tax, because we're all gonna die, right? And we're most likely gonna die with property. Now, owning property and dying does not result in the imposition of a tax. There's an estate tax, and it applies to some people, not all people. It doesn't apply to me. It doesn't apply to most people in the room. So if you were to pass away and the value of your estate is less than $12.9 million. Okay, you're welcome, right? I got you covered, no worries, right? You're but it's true, right? So the idea that a normal person with normal assets, normal income is going to be subject to estate tax is not accurate. And again, this is one more thing that should make us feel great. We don't have to do anything to opt into this system. It's just what it is. So let's not worry about it, right? When you have to start worrying about it, I'm not worried about you, right? You can pay some tax once you hit $13 million, right? Or if you're intent on avoiding it, that's fine, right? Give me a call and you can talk to a tax, you can talk to a tax lawyer, and the point is, you know, we don't really have to worry about that. You can't really see it. You can see it if you squint on your paper, but it shows that in a given year, only 0.2% of the deceased person's estates are actually subject to the estate tax. So does this affect a large portion of our population? Absolutely not. Now, that's tough, right? Because when you say that, most people have one of three opinions. Big shrug, I don't care, one way or another, right? Some people will say, well, that's good that they're not subject to an estate tax, they work for this money, right? And it shouldn't be subject to a tax on death or transfer. And the other approach is that some people will think, hey, $13 million, that's pretty high. How come they're not being the taxes that proposed? That's a missed opportunity, okay? I don't care what your preference is. I'm not going to tell you what mine is, but we just talked about a spectrum, right? And the fact that there's these three different approaches that people feel strongly, it points to an important thing about the estate tax, and it's a political football in certain. So those three things that I just identified, they can be mapped to a certain degree on different political parties, and I present this graph to you in this way. It starts at 2001, skips some years, and then goes to 2003. In 2001, the estate tax exemption amount was $675,000. Okay, So in 2001, there was more than 2/10 of the percent of the population that was subject to it, right? We dealt with inflation, et cetera, right? But if it was still $675,000, we would be having a different conversation. If you'll look, 2017, it was $5.5 million-ish. 2018, it's $11 million, change in 1 year. And so that aligns with a change of a presidential administration. The Trump presidential administration decided that it was one of its priorities to significantly increase the estate tax exemption amount. And as a result, 1 year to the next, they doubled it. Okay? And so from a political perspective, I'm not very interested in that, right? From a planning perspective, and as far as me being concerned about you, the reason that we care is that it can happen again. Right, it could flip in the opposite direction, right? I use that to illustrate the fact that while the graph shows that it's gone up consistently, 2 years ago, there was a lot of conversation about will the Biden administration roll it back? And this is a long way of saying, right? Pay attention to the news, okay? And if you see that there's a major drop in the estate tax, stop, ask yourself, what's the ceiling, right? What am I dealing with? Think about what you have, total assets, et cetera, and say, do I need to get proactive all of a sudden? The smart money says, and so when they were having this conversation 2 years ago, the people who paid tons of attention to this and like to write articles about it, et cetera, the consensus was it won't drop below $5 million in person. Okay, we don't know. Again, it's a political animal. We don't know, but point is, let's not worry about it until it's a problem. So again, this is kind of a myth busting opportunity right there. And then just in case it were to drop, part of this, guys, is about demystifying, making this feel more relaxed, et cetera. But even if it were to drop, taxes only apply to the amount over the exemption amount. So if you were to die with $13 million even, you'd end up paying the estate tax only on $100,000. So whatever the exemption amount was, it would be applied to $100,000, only the amount that is the exemption amount. So even if it drops in the future, right, and you experience a windfall or something like that, the full exemption amount is going to be able to be transferred without being subject to any tax. So this is my feel good slide. Okay, this is my don't worry slide. This is my good news slide. Would you mind advancing it? This is my scared straight slide. Okay? Do not mess around. So we all live in California, and probate, trust, right? We talk about trust even though we're dealing with normal amounts of assets, everyday people sort of stuff. And so you do not need to be a member of the Gates family to be concerned about probate in California, right? It's a 4-letter word in our office, mainly because it's avoidable, right? And we're not trying to circumvent a tax or something that's relevant. Probate, what's probate? Probate is the process where the court supervises a transfer from a deceased person's estate to his or her surviving beneficiaries, okay? Well, why do we need probate? It's actually pretty important if you think about it, but just a quick illustration. If you were to go to a bank and you knew that your uncle left you $200,000 and there's $200,000 in the bank account, you went into the bank, you presented them with a will, you identified yourself, and you identified the fact that your uncle was deceased, okay? And then you're gonna ask the teller, fork over $200,000, right? Because the will says that my uncle's deceased, right? You satisfied all the elements, the requirements. That's a lot of money, right? Banks don't want to get sued, right? Banks are very concerned about liability, and that's fine because we trust them with our money, et cetera. And so they should be. So the probate process is what was devised to enable our society to make the banks trust a request. And what it is basically is a court process where a party who's interested, me, I want the $200,000 gift from my uncle, goes to the court and says, my uncle's deceased. So we're basically presenting that same information to the court instead of a bank teller. And then the court has a process where they make you give public notice. They make you submit what the will is. They make you make a claim under penalty of perjury. This is in fact the last will that I'm aware of, okay? And then there's a waiting period where we let people raise their hand and say, right, that was my brother, who is your uncle, and I have a will that was dated 3 days afterwards, 2 years afterwards, whatever it is, okay? And that's good, right? We want to be able to flesh it out, make sure that we're all in agreement regarding what the valid controlling document is, because if we don't, think about it if this was a home, right? Let's ignore $200,000. Let's say that my uncle left me a home and I was to claim ownership of the home based on a will. If you think about title insurance that you had to deal with, or the last time you had to deal with buying or selling a home, right? What's super important is being able to determine, do I in fact have the authority to sell the home that I'm selling you? And should I be giving you money, will you be able to transfer title to me so I can take ownership of it without worrying about the brother coming back and saying, hold on, this is my house, right? And then you're saying, well, I just handed over however many hundreds of thousands of dollars. And then the uncle says, I'm sorry, the brother says, I'm sorry, but I have a superior claim, okay? And so there's a reason for probate. It stinks, we're not excited about it, but from a societal standpoint, it's super logical. And so that's a long way of saying, right? Why do we have probate? So that we can secure and verify the process where we transfer assets from a deceased person to the surviving beneficiary, okay? How do we make sure that it's locked in and nobody can come back and undo it later? By submitting it to a court, by having a waiting period, by having public notice, public hearings, okay? And by the time you're done, you can lock down title, you can lock down ownership. And if brother comes back 3 years later, I'm sorry, brother, right? You were given notice. We went through a court period. Even if you didn't specifically receive notice, we published it, we followed the rules, and society can move on, right? And you can sleep comfortably in the house that you just bought from the nephew, knowing, right, that it went through the probate process, and so I don't have to worry about my ownership being upended or something like that. Net positive, right? It's great, super cool. It's not efficient. And it can be avoided. So if you have a will, and if all you have is a will, the process by which you establish ownership, verify the ability to make transfers under the will, in most cases, and we'll talk about the exceptions, you have to go through that probate process. So wills are great. Wills are very effective. Wills enable you to avoid the graph. Remember the chart with the default settings, right? Wills enable you to avoid that because I don't like my sibling, right? And I don't have children and my parents are deceased, so I don't want that to happen. Great, you just write a will and it'll work. It'll totally work. The process of so we're talking about, you know, good to great, right? So good, you skipped out on the default law in California, okay? Not great. In order to get there, it's gonna have to run through a court. I love DIY approaches. I'm an attorney, my hourly rate is high, and I don't like that. It makes me a tad uncomfortable if I'm being honest, right? I deliver great value wherever I can. I don't charge if I can, so I don't care. I sleep with it, I'm fine, right? But I don't like it, right? It makes me uncomfortable. My wife explained to me that we need to keep paying our mortgage. And it's awesome living in Loma, and she also had to explain that it's not cheap in that neighborhood. And so I was like, oh, right, okay, gotta pass that along. Because I know I'm delivering that. Okay, so don't worry about it. But my point is, I like DIY approaches, okay? I like empowering people when I can, because I got plenty of work and I don't need their money, right? Not right now, right? But either way, it's the honest thing to do. And so when people can get away with the DIY approach, I'm all for it. Probate, you can't, you just can't, right? And that's a bummer. I've had people come to me and they're like, it's a really small estate. I'd prefer to avoid an attorney. And this was a long way of saying, I'm able to say to them honestly, I prefer you to avoid an attorney too, right? But it's so form-based, the procedural requirements are so detailed that it just, I've never, it's 1 in 100, right? You can comfortably walk through. Why is that a problem? Because fees are based on the value of the assets, Okay, this is a long way of saying, well, what is it that we dislike about probate? We know that we like the fact that it's effective. Well, why not just rely on it? Because the attorney and the executor are both gonna get paid as a percentage of the total value of the estate. So let's just look at a quick number. And this is easy in Southern California, if you think of it. Let's say that the fair market value of the property owned by somebody on death is $1 million. The attorney is gonna get paid $23,000 to walk it through the process, to walk it through the court process. You wanna hear something amazing about it? It's fair market value of the property. Okay, so that means if you own a home, and you're carrying a $750,000 mortgage, you only have $250,000 in equity. You're not getting billed based on the equity, you're getting billed on the fair market value, right? So you're paying an attorney $23,000, and then you're paying the executor, okay, another $23,000. On top of that, you're gonna wait 6 months, if you're lucky, more likely it's gonna be 12 months. Just to work through the notice process, the waiting process, the court scheduling, etc. So, you know, this is the bad news page, this is the scared straight page, okay? And, okay, exceptions, right? Exceptions. This does not apply to everything. It doesn't apply to everybody, because again, we're not here to scare people, right? The total value of your assets is under $184,000 and it's not real property. There's a side approach to it. If it's under $184,000, where you can skip probate. Okay, it's a super simple affidavit. Bank account will release it based on the affidavit, etc. So that's a big exception. If your assets are going to be transferred according to a beneficiary designation, okay, that's a non-probate transfer. So you get to skip the probate process. It's wonderful. Okay, so if all you're dealing with is a 401k, bank account, and you know you might have some other property, let's say a vehicle. So long as you have your beneficiary designation properly executed for the 401k, you can put a beneficiary designation on a bank account, right? You just enabled the beneficiary to receive it immediately following your death. No delay, no attorney fees, which is awesome, right? All the other properties, so long as the cumulative value is under $180,000, you can also move that on, right? So don't walk away thinking, if I die and my total value of my assets is over $180,000, we must go through probate. It's not accurate, right? But it's important to keep this in mind when you're thinking about it. Total value of real property that you can transfer without probate is $50,000. I'm pretty sure it's just an easement to walk through your neighbor's yard or something like that. There's nothing in Southern California that's worth less than $50,000. But so this is why we care, right? So my shorthand for this is, if you own a home, you should be paying attention to the probate rules. If for some reason you're holding a lot of cash in your name as an individual and not in the name of your trust, you should be paying attention to the probate rules. Would you advance the slide? Thanks. So now we're back to these documents, right? And so why is it that a trust works? So a trust is like a box. So think of it just like a box. So what you do is you transfer ownership of the asset into the trust while you're living, okay? And you do that by updating title on either real property deeds or the name of the bank account. And what you just effectively did is you put it into a box. And you are the person who established it. You're also the trustee, so long as you are healthy. If you lose capacity or if you die, your successor trustee is going to come in. But that's a non-court process, right? So what you're able to do is you're able to just take the box holding all the assets and pass it to the successor trustee that you nominated. That process takes a week or two, right? It doesn't involve the court, and it's very, very effective. It's used every day and it works. It's extremely effective. And so, you know, why is it that our trust enables us to avoid the probate process where a will would require it? Because you established somebody who has the authority to make a distribution of your assets. That was you during your life while you were the trustee. You had the same office as filled by a different person. And that person will be respected by the banks, they'll be respected by the county recorder, the assessor, and they're able to follow your instructions as listed in the trust document regarding making distributions according to the instructions that you gave in the document. So I talked earlier about the concept of the person who has the power to execute and the person who has the power to give instructions regarding what they want. While we're alive, it's united, okay? When you lose capacity, you die, it just stops split. The important thing is you were able to give your instructions in the document, and then the person to whom you gave them has the authority, because of the way that you gave the instructions, to carry out your wishes. And it's just an example of good planning. And so they are effective. We still use wills as a backup document, and we say the will, all it says is anything I own subject to the will, put it in the trust. If you're relying on a will, you still have to be worried about probate. But let's talk for 1 second about the right-hand side. Incapacity concerns. So same concept. While you're alive, while you're healthy-ish, while you have capacity, you leave instructions in the form of a written document. You execute it in a format that's going to be accepted by third parties, okay, which means you sign it in front of the notary, right? You follow a particular format, you use a particular type of form. And again, you give your instructions as the principal, you identify an agent to carry out your wishes. And then at the time that you lose capacity, you can't go to the bank yourself, or you can't speak up for yourself to your healthcare provider, the agent that you nominated, that you chose, that you instructed, is able to present the document to the third party, the bank, a healthcare provider, and they're authorized and directed to follow the instructions of your agent. They work wonderful, right? They're great. And I like DIY, they're free, okay? They're online, California statutory forms, power of attorney for asset management. You can just look it up through Google or an advanced healthcare directive. If you go to Kaiser has their own form, which is wonderful that you can ask for. And you just follow the instructions. Generally speaking, you don't really need an attorney unless things are getting weird. So, you know, if you haven't done it, do it. Word to the wise. So legally speaking, advanced healthcare directives from a legal perspective are valid indefinitely until they're shown to be invalid. Practically speaking, it's not every time, but every once in a while, healthcare providers will say that a document is stale because it was executed 12 years ago. And that's strange, right? We don't like that. So word to the wise, right? It's worth, while your trust may be fine, trust law moves really slow. It may be fine just to leave it. It's worth re-executing an advanced healthcare directive if all of your other documents are a decade old, right? 3 years is wonderful as far as healthcare providers are concerned. But if you don't make it, or if you aren't able to do it, your agent will just have to maybe push a little harder, or maybe they're not even. So, what we've done by coming back to the Venn diagram is, you know, we talked about a default approach in California, and the fact that you don't have to take a proactive step to carry out your wishes. We just talked about some of the downsides of that. The downside of not having a power of attorney for asset management stinks, okay? You can't keep getting your bills paid, okay? Because the bank only wants to take your instructions, okay? It's so difficult, actually. It's a free form and it's simple. It's so difficult because how do you get a bank to recognize the authority of the person who cares about you and who's trying to help when they don't have this document? You gotta petition the court, and it's terrible. It takes a long time, right? So this really is an instance where an ounce of prevention can lead to very serious consequences when it comes to keeping your life going the way you want it, continuing to live where you want to, eating the type of food that you want to, etc. So this is the other side, right? This isn't the default approach. This is I'm gonna invest some effort, take some time. You guys are sitting here, right? You guys have talked about the other things. It's worth making sure that these things are in order, and it's worth taking time to execute them. So one thing I'm gonna say about that, again, real briefly, trust law moves slowly, okay? Tax law moves fast. Immigration law moves fast. Trust law moves pretty slowly. So generally speaking, when people come in and they say, I executed this trust 20 years ago, 15 years ago, 10 years ago. I want to make sure everything is still up to date. It's up to date. Don't worry about that, right? If someone's gonna tell you that you need to pay them $500 to review it, just call me. Because it's not how it is, right? It's not, it moves so slow and it's the best. It moves so slow, so I was able to go to Borrego this weekend and I was able to go on vacation a year ago or whatever it was. It's a great area of law in that regard. But one of the things, so it's not the law, right? It's regular life that changes that we need to be concerned about. So when people come in and they're asking me to review their documents, is this still valid? Is it gonna work? I'm saying legally speaking, yes, it will work. But is the person that you nominated still the person that you want handling this for you? But is the agent still the right person, right? Is the person that you nominated, are they your same age? Are they your contemporary? Are they likely to have the same problems that you're gonna have? It made sense when you executed it, right? And you were young and 41. Because you're so young at that point. And so your contemporary wasn't a big deal, right? Because they were gonna get called upon in 20 years or something like that, they're ready to go, right? But if they continue to age with you and you've had that pleasure, right, of being friends for that long, or sisters or brothers or whatever it is, you guys may need help at the same time. So changing your agent nominations is one of the things that actually does require attention. Making sure that it's the right person to actually do the job. So this person is suddenly going to become intimately involved in your life if you lose capacity, okay? That means they are helping pay attention to your personal needs, your personal hygiene, your care needs, right? They're messing with your checkbook, okay? They are potentially saying you don't have enough money to spend on that, okay? And so I love your children, you love your children, but choose the one that you're gonna feel comfortable taking instructions from if you have to, right? And acknowledge that it's gonna change the dynamic a little bit, right? And so you make sure it's the one that you're comfortable with. And if there's none, that's fine. California has a really cool, so if there's none, and you have a friend you can trust, a niece or a nephew or something like that, and they know how to handle a checkbook, they're not an idiot, they're not married to somebody who has, alcohol problems. Great, that's super. If you find yourself in a position where there's nobody that you know in your personal life, I have plenty of clients who find themselves here, right? Maybe they moved, maybe they're the sole survivor, maybe they had to change the course of their life and leave a lot of people behind. California actually has a super cool solution, and it's the Certified Licensed Professional Fiduciary, CLPF. And so they're private individuals. We think of them kind of like, they're like part CPA, part financial advisor. They're like professional adults in a lot of ways. And so I'm just gonna say, if you find yourself in a position where you don't have somebody that you have a personal connection to that you can nominate, CLPF, they work based on an hourly basis. They don't start to get paid until they start working for you. They aren't just you're not gonna nominate them 3 years later, they're sending you a bill every month. That's not what happens, right? It's a cool profession. And so they are professional agents. They are professional executors. They are professional trustees. California has a way to license them, make sure they're bonded, things like that. It's not like that in every state, and it's a really good opportunity. It's a great alternative. Would you advance the slide? Yeah.
What does the P stand for?
Professional.
Professional, thank you.
Okay, the other big thing that people come in, the other reason why people need to update their estate plans. Normally I scribble all over the place. This isn't gonna work right now. But we have an AV trust on the right-hand side and survivor trust on the left-hand side. The one reason that people come in and they say, the law, nope, the law hasn't changed, you're okay. The law has changed, guys. We're just saying, like, is it worth upending your entire apple cart for it? Sometimes it is. Don't hear what I'm not saying. Sometimes you just really need to do that. And so don't hear what I'm not saying, right? The law does actually change. There was a huge change regarding property tax in the last 2.5 years, and transferring it from parent to child and that sort of stuff. So I'm not saying don't talk to attorneys. But the one big thing that is causing people to make major changes right now is that they have an AV trust. And AV trusts were important at one point because of tax reasons. What's an AV trust versus a survivor's trust? AV trust on the first spouse's death. If you're single, you don't worry about this. AV trust on the first spouse's death, the assets are split in half. One goes into an A trust for the surviving spouse has full control over that. One goes into a B trust, it's an irrevocable trust, okay? That was necessary for tax planning reasons a long time ago. It's still very attractive and useful to people who have blended families and are really concerned about that, or they're worried about the bimbo girlfriend or beautiful pool boy or whatever it is, right? Like, they're still effective, there's reasons to have it. But there's all sorts of families who aren't well served by it. And so those are people who every time I'll say, you need to restate your trust, you need a new one, it's worth the money. Because in a survivor's trust, there's no required split. And because there's no split, you save a ton of money on administration on the first spouse's death. It's a lot easier. You only file one tax return each year instead of two. So that's one of the clear exceptions to what I'm saying.
Can you choose either or?
Absolutely, 100%. But the thing is, it's baked into your document when it's written. It's baked into your document right now. So you either already have a survivor's trust, which plenty of people do. I reviewed a trust for a neighbor last week, executed 20 years ago. He went with a survivor's trust from the beginning. Okay, so plenty of times, but it's in the document right now, one or the other. So that's a response to blended families. I'm gonna go 3 minutes over, although I still have 23 seconds. Special needs planning, right? If you have a child or a beneficiary who's receiving government benefits that are needs-based, okay? Super important. We can talk more about it later or ask questions in the question period. There are ways that, so if you were to give the money to them outright, you're gonna immediately disqualify them. And so it's such a terrible process, right? It takes so much energy and effort to get them effectively qualified. You wanted to do something good for them, and in spite of your intentions, you just cause them to restart that process. And it's terrible, right? Also, they lose access to the benefits that they're entitled to, or that they've earned, or that they deserve because we're a just society, or whatever it is. They just lose it, and it'll just spend down the money. You can take an extra step, which is to set up a special needs trust. It doesn't have to go into effect until you die. You don't have to fund it during lifetime. And what that does is it specifically restricts the way that the money's used so that it doesn't fall afoul of the requirements, and they can continue to receive their medical benefits, their housing assistance, whatever it is. So there's a solution. And then one of the questions I believe was, parents in these situations, or spouses or siblings, whatever it is, this takes a ton of time and effort, right? I've heard being a parent takes a lot of effort. Thank you. I don't have any kids. But people with special needs trusts, whenever I work with them, it's particularly tough because they remain in that capacity for so long, right? And it's stressful when they're gonna die and nobody's there. So one, private professional fiduciaries are a great solution if there's money, okay? If there's not money, your goal is to get them into a stable living situation that doesn't require your regular intervention. And there's something awesome in California. So California has pooled trusts systems. California, or San Diego, has the Special Needs Trust Foundation, SNTF. And it is a low-cost approach where they basically, it's a low-cost approach where if you can't afford a trustee to supervise a special needs trust post-death, pooled trust is one of the ways that California has come up with dealing with it. And what they do is a nonprofit entity, they're supported by attorneys and professional fiduciaries who are all donating their time. And it's something we can talk about more if cost is an issue. And cost is always an issue in these contexts. I think that's where we're gonna stop, given that I'm over, but plenty of time for questions.
Can I just make one comment?
Yeah, yeah, that's the thing. Everybody in here has some experience.
In the Japanese plus, on that focus, it's also really important that if you have other family members, that they don't decide to will money to your special needs child, because again, that would disqualify them from their benefits.
100%. And so if you have generous relatives or your child or your dependent is part of their planning, that's one of the times where it's worth establishing a special needs trust during life and not having it created. I'm sure you could explain this to everybody as well. But the concept is you create the bucket while you're still alive, and then you can share that information with your loved ones. And instead of naming your child Susie as the beneficiary, they say Susie Special Needs Trust. It's right, and it works just as well as you hope it.
Well, I'd like to field any questions that you have for Adam. So who has a question?
What, you mentioned the word real property, what is the definition?
Thank you. Yes, great question. So, we're gonna start with the unlikely to the likely. Mineral interest, oil rights, easements, right? Your home, right? Your home, condominiums, houses. It's just it's a legal catch-all term.
Not your furniture.
Thank you. Okay, yes, now why doesn't it apply to that? Because furnitures don't have title, okay? And so you can make a transfer of a furniture without the intervention of this assessor, without title insurance, with all those things. So there's fewer requirements. If all you're concerned about is your physical possessions, wills work great. They work super. You do not have to, now exceptions, remember $180,000, okay? If you happen to have a very expensive RV, car collection, something like that, figure it out, do some planning, right? But otherwise, and let me just say one more thing about that, Connie. Parents put in so much effort during their whole life. I really appreciate that. I was split earlier, but sometimes that will or a memo regarding the distribution of tangible personal property is your final act of parenting. Okay, you can save your children a ton of grief and strife, right? By spotting in advance grandma's tea kettle. I talk about grandma's tea kettle in my office all the time because it's real. I've sat in the back of the court and watched people make it all the way to trial about something that has a retail value or resale value of under $100. But they're fighting, right? Because they didn't get along when they were children. Okay, and so if the parent, if the owner had left something that just, you make tough calls all the time, I'm sure, as a parent, right? You just make one more tough call. And you say it's going to you, not you. Or you guys thought about it, it's going to that person. It's one of the things that you don't think about because the financial consequences aren't significant. It's super, super important. And if money is a motivator, it saves a ton of time on attorney's fees too. But if just trying to establish relationships, etc.
Since a car has a title, that would have to go in also.
Thanks for asking. There's exceptions, right? There's always exceptions. So the DMV has a form. The DMV has a form that you can transfer ownership without going through probate.
Oh.
And then also, generally speaking, it's not worth transferring ownership of your car into your trust during life because the pour over will says that it goes to the trust. Number one. Number two, the DMV has a really simple form. Number three, and this is like an inside baseball tip. Sometimes people get weird if they rear end you and you guys have to exchange registration information and they get mixed up and they don't think about a normal family trust and they think it's the Gates Foundation trust or something like that. So maintain the privacy, there's simple things.
Is that something you recommend while we're still contemplating?
Great question. No, give instructions via your will, but it can only happen post that.
Okay.
You have a question here?
Yeah, so I have two questions.
Mhm.
Like at Chase Bank, when you tap on a beneficiary, there is payable on debt
Mhm.
or in trust, whatever. So that's my first question, because I kind of don't understand that. And then my second question is for spouses in California. We don't need a power of attorney to pay our bills or mortgage, right? Unless the house is.
Two great questions. I've got two answers for you. One you're gonna like, one you're okay. Pay on debt is how you circumvent the trust and circumvent probate. So when I say you just fill out the beneficiary designation and you'll be good, it's great, right? Because then what happens is if I go to the bank, right, and I provide a death certificate, they check the account, there's pay on debt. If my name matches the pay on debt designation, great, no problem. Now in trust, I'm not 100% sure about this form, but sometimes it's indicating the transfer to a trust post death, but the pay on death designation is how you get around it. Now you can also pay on death to a trust if you want, something we're thinking about. But that's the mechanism. Number two, you are married. It's California. Shouldn't that be enough? No. I mean, on an informal basis, you may find somebody who's really helpful. Okay, there's not a default lot. If both of your names are on title, no problem. If both of your names are on the gas and electric account, no problem, right? If the one spouse is responsible for it and the other one gets to deal with something else instead of that, and you know, her name is the only one on it. He's gonna have enough of a problem that it would have been way easier to just fill out one of the forms. I'm gonna say one other thing real fast, not subject of a question, but it's super important. Some people take a DIY approach, said I like them, DIY approach of saying, I'm just gonna transfer ownership of my home to my child, to my children while I'm living, so that so that they can skip the probate process, okay? Bad idea for tax reasons and liability reasons. Number one, it was a real transfer, right? You really just transferred ownership of your home to your child. And if that child has a car crash and they're the subject of a suit and they lose, right? They're going to your home to satisfy the debt. Now, there's certain protections for homes, right? There's minutia here that will offer you some protection, but it's a real transfer, so don't mess with it, right? It's dangerous. Number two, it messes up your capital gains tax. So if you hold ownership, so Southern California real estate is crazy. You bought a home for $50,000, you paid it off, you've been living in the same home for 25 years, right? As it turns out, $50,000 is now $450,000. You can transfer it and it's not gonna cause necessarily a taxable event, but if your child then goes to sell it, your child has a basis of $50,000 and is gonna pay capital gains tax on the $400,000 of gain, okay? Capital gains tax is hard to avoid, okay? However, if you had held it until death, the basis steps up on your debt from $50,000 to $450,000. You just wiped out $400,000 in capital gains, and your child is able to receive it, turn around and sell it if they choose, and there's no imposition of capital gains tax so long as there hasn't been any additional gain. And if there's a gain, your child lived in it or rented it out for 2 years and it's now $500 instead of $450,000, the gain is only $50,000. Okay, and you miss out on that when you do a lifetime transfer. You miss out.
Question?
Yes, so when you're talking about the probate and there's $1 million house that I'm waiting on from my dear dead uncle. And I'm gonna have to pay, he was a great guy, and you have to pay $23,000 in estate fees. Am I paying that $23,000?
Yeah, good
Like
question.
out of my pocket? What if I don't have
The
it?
house is gonna get sold.
Oh, right out of my
That's
face, I can't afford the taxes?
I'm sorry.
So like the house, so sorry, go on, the house is gonna get sold?
You can't, let's say you don't have $23,000 cash, the estate owes $23,000 to the attorney, $23,000 to the executor, and if the home is the only asset, the executor has power to liquidate the house to pay, because it's a debt, just like any other debt. Yeah, that's the truth. You might be able to strike a deal where you say, I'm gonna pay you over XYZ number of months or something like that, but I mean, truthfully, what happens? You refinance the house and you pull cash out.
Oh, yeah.
Right, and there's plenty of ways to deal with it, but that's an indication of the strength of the attorney's claim.
Other questions? Fine.
I know there's different powers of attorney.
Yeah.
And kind of, what are the most important ones to have, or
Yeah.
I don't understand that.
Power of attorney, very simply, is me giving power as the principal to another person to act on my behalf. Okay, so sometimes they're only for a specific purpose. Sometimes I need to go on vacation and I need to complete the sale of my home while I'm serving in the military or I'm on vacation or something like that. You can give a power of attorney to a specific person for the purposes of completing the sale. I just say that as a way of saying, as a way of clarifying exactly what they are. The most important ones, that's very narrow applicability. The most important ones, power of attorney for asset management and advanced healthcare director. The power of attorney for asset management, the statutory form that you can find by Googling it, has them all listed. And it says for banking, for bill pay, for like tax filings, all these things, or it says option N, all of the above. You just initial all the ones you want to give. It's easiest just to initial option N. So long as you're trusting the right person, that's the easiest approach. Healthcare, same sort of thing. you were able to walk through the form and it walks you through. So those are the, just start with those two.
Okay. Well,
And don't worry about the
basically,
rest.
Advanced health directive is your power of attorney for health.
It's united because you're giving instructions, so that's the directive. But you're nominating an agent to communicate on your behalf, so they just combine it.
Any other question?
Yes, it just came in, now it's going out. Okay, I have to renew my will and trust because the old one, people are dead, everything's different. But, I've talked with a cousin and she's willing to be my power of attorney. But could I say if she's not living, could a CLPF be appointed?
Can and should.
Okay,
And number one, guys, I said I love DIY, right? That's worth paying for, right? Your beneficiaries aren't the right people, right? Don't shortchange yourself, right? And say it was gonna cost X, Y, Z in attorney's fees, right? Pay to get it fixed, right? But yeah, you should 100% nominate a primary, a secondary, if you have somebody, a tertiary. And so what you can also do is say, I'm nominating my cousin. My cousin's not able to act. I nominate a specific as in a person. And if not, then you say, if my cousin can't act, I want my cousin to select one for me. And they need to have this designation.
okay. Thank you.
Mhm.
Yes.
Yeah, from what you said, it sounds to me like whoever you choose as your agent needs to be someone who is close at hand, not a sister or brother who have another country.
Okay, actually, so other country is a special reason and for taxes, there's a tax problem there. And your trust in a state is gonna have to be taxed in advance every year, and the amount is way higher than you would expect. So that's one of the best reasons to avoid it, right? But number two, from a practical standpoint, they need to be able to help you. And so if it's something that they need to be personally there for, then yeah, they need to be local. But I can tell you, right, that there's plenty of times that people only can rely on somebody who's out of the state. And what happens is they fly out to get you set up, right? They identify somebody who can help, a caregiver, a local bill payer or something like that. And you can do a ton of stuff from outside of the state. So it's a yes or no sort of thing. But what I say in those circumstances to people is financial issues, not a big deal. Healthcare issues, it would be better if they were in the same time zone and could be there relatively quickly. And then also the other thing is you can put them first, you can put your neighbor first, your friend first, and then your out of state person second. Because a nomination is just a nomination, they can always decline, they can always stop and step out. So at least on the healthcare one, put them in, put somebody local, put your other person second, and they can step down this time.
Another question?
Yeah, if a trust is created, for example, in California, and I'm thinking a trust that has a special needs trust addition, added to the supplemental trust attached to the trust, and brother and brother were to move to another state, is the trust that was created in California followed wherever they would go, or?
Yes and no, right? So that's a really tough one. And so estate planning laws are resident specific, right? So they're governed by the state where you're living. Now, to the degree that it deals with federal benefits, it's probably gonna work. And even to the degree that it deals with state benefits, it's probably going to work. And I say probably, because the state where they move to, generally speaking, generally speaking, they're gonna do their best to interpret California documents according to either their own law, or there's a provision that says this is to be governed by California law wherever you are. So it's one or the other will appear in the document, or you'll just default to it. So, you aren't gonna be able to plan for all those things. And so, generally speaking, you've done a good job if you've gotten to the point where you've established the document. And, if you know in advance, it's worth asking an attorney in the state where they've moved. But I can tell you in practice, you're gonna ask him or her, she's gonna say, I'm sorry, I'm not a California expert, and that's true, right? And then they're gonna say, I can redo it for you.
So that would be reconciled to the state that they.
Yeah, and that's where, that's well spent money as well.
Got it. Thank you.
Anybody else with a question?
Do you have a card that you'll give us?
This is a sales pitch, it's not. I do have some cards on the table, not a sale.
That was something that I said, don't forget to bring your business cards.
Wow.
One more question.
Is there a difference between an advanced directive and pulse?
Yes,
One
there is.
is better than the other?
No, do both, and make sure that they align,
No.
okay? Because if they don't align, the last executed one is gonna go, or it's just gonna cause confusion. They're both good, but they should align.
So advanced directive and what?
Oh,
POHL.
the POLSP, there's one on the table, and generally speaking, you can talk with your primary care provider while you're filling it out. I think that's actually one of the instructions on the back. But even if you can't, they're good to fill out because they give real clear instructions.
And it has your primary care signature on it. So
Yeah.
So there's copies here.
Oh, yeah, and so related to that, if you have an advanced healthcare directive and you fill it out, call your healthcare provider and ask where you can email it, fax it to, mail it to, drop it off. They'll put it in your file, and so it'll follow you around, which is.
I have a question.
Here.
Okay, so I know that very intelligent, much more intelligent people than me have gotten scammed.
Yeah.
And that happens more as we age.
Yeah.
And, so is there any mechanism available where you can, preclude somebody taking advantage of a senior citizen in advance of a doctor saying they are not capable of making decisions?
That's a really good question. I had somebody ask me that at work last week, and it's tough, right? It's tough. Answer, yes, there is. And so doing it in advance involves letting the door open a little bit, making yourself a little bit vulnerable to a trusted person. But if you bring somebody in early and you give them power as an agent effective immediately, or they're your co-trustee effective immediately, they're standing alongside you. And then what you end up doing is, if you're concerned with big things, right? Title to your house, you update title to your house, and now you guys are on it as co-trustees of the trust. So if somebody were to try to refinance your house without you knowing, or sell your home out from under you, and the individual, not you, the individual who is aging and is vulnerable, et cetera, may be having a problem, there's gonna be, that's your protection. There's a second person signature that's somehow required, right? So you make an agent effective immediately to work on alongside of you, and then you just go asset by asset, because there's no simple way to do it. There's no single document, that there's no solution to that right now. It's such a complex problem. But you focus on the things that you're most worried about, and then you go to those places and you say, I have an agent who's acting right now. I have a co-trustee who's acting right now. I want to add him or her on my account so that both of us have to authorize expenses over $10,000. So both of us have to authorize refinancing or opening up new lines of credit. You're gonna get various responses depending on how willing they are to help you. Yeah, it's really tough, but that's the best solution I'm looking for.
Thank you. Okay, I don't know what time it is, but I.
1:05.
That's why.
So, please fill out the feedback form and leave your feedback. There are numerous handouts here from previous presentations. So if you don't have one already, take a look at and take one. We're here to help.